want to get into the laws that are now in place and a lot of what we've seen happen in the past few days. So court being told by Jubilee, don't you go celebrating yet on that ruling and 8 sections being suspended. It's going to be a protracted one in terms of ensuring they have their way on these laws. Your thoughts, Senator?
You know, Jubilee thinks about pomp, champagne, pop champagne, social media. We think about nation. It's not about champagne. It's not about winning or losing. It's about a country. You know, this jargon of the Onyango laws of this world should be ignored. This is not about popping champagne and stopping to pump, you know, whatever it is, pop it or stuff. But I think one thing is these days I have a social media monitor, and we've become an area of interest to us because we are here together all the time. I saw you posted a comment asking Jubilee why they consciously have published an unconstitutional bill. Why? I saw that on your Facebook page, unless somebody is operating under disguise of weather. And I felt, but I know one thing people first need to not lose sight of. What Jubilee has done with this particular bill is to go and act now, which is this bill into an act, which we always are referring to in quotes because we still believe it has no legitimacy to be an act of parliament, but there is what the court says implied legality. So that said and done, this is akin to slapping your wife very, very hard, and then taking her for dinner later to tell her how non-violent a guy you are. But I think what happens, this was a demonstration of intent of what were the issues, what reversals Jubilee had wanted to do in terms of just amending arbitrarily the Constitution of the Republic of Kenya. You see, you're thinking about eight laws or eight sections that were stopped. The 11 sections were also dropped off before the bill became an act, and those were the areas that had nothing to do with security. They simply wanted to muzzle our freedom of expression, freedom of speech. You know, they wanted us not to picket. They wanted to designate places to picket. They wanted to deport Kenyans without the rule of law areas and stuff like that. Right. So so the public had already scored a significant amount of success by the time the chaos that erupted, that enacted this act, was witnessed in Parliament. And still after that, we said, in the National Assembly to be more precise, and still after that, the human rights actors were still convinced, the CORD coalition, that it had still not met the threshold that we were talking about. So CORD had filed a petition with 2 prayers. One, either that the entire act be suspended or stayed, or in the alternative, certain sections, we had listed 12 sections to be suspended, and the judges suspended 8. Because what he decided in the other 4 is that if eventually a few safeguards were put in, because even that bill also was refined before it became law, where we put in safeguards. Right. When, let's say, Duale talks about the fact that all interests of Muslims have been catered for, he simply means that in the revocation of an ID, now an element of court was put in. I was so incensed when he said that on Jeff Koinange Live. I said, who said the interest of the Muslims is only IDs? Muslims have a general interest about how this country is governed generally. It's not, don't box us and myopeize us into some kind of sectional, issues about just the fact that we think IDs will be revoked. We also are fearful of our rights generally. So then eventually Justice Odunga, and this is my last comment, suspended 8 laws, which I want to criticize the media for. But I don't think we were doing it on our behalf. You see, the media had threatened it was going to go to court. We were going to go to court. We were going to go to court. Media should zealously safeguard its freedoms, its independence. Immediately we went to court. Every other person, Katiba Institute, Kituo cha Sheria, I think Article 19, they came in as interested parties. They sent lawyers to the cause. KNCHR filed a separate petition. I'm waiting to hope that you will apply as an interested party so that at least you are able to prosecute your interests within the purview. In fact, the 2 sections that affect the media, I think section 12 and 64 have been suspended, and at least you can still continue with Jichopevu. All
right. Henry, let's hear your thoughts on the same.
One, I think we need not have gotten to this stage. As a country, there was a clear understanding and unequivocal
Do you think there
acceptance.
was a gap in the laws that were before to warrant new laws to ensure security was...
The truth is, there wasn't a gap.
Okay.
A serious analysis of the current laws, and I would want to begin by the Prevention of Terrorism Law, for instance, which gave investigative agencies 90 days. So far, all the cases that have gone to court, they've not sought beyond 30 days. And that is a fact. We've done an analysis, and here we are changing from 90 days to 360 days, saying it is informed by their ongoing practices that they did not have time. So one of the things that is very clear why I'm saying we shouldn't have gotten into this space was a comprehensive analysis by police and by the office of the DPP to say these are the gaps that we want you to deal with. The issues that we are identifying as gaps are whimsical thinking of certain people who sit in the Solicitor's General Office, some of them who sat in Parliamentary Committee on National Security and on the Defense Committee. That was not comprehensive enough. You cannot begin dealing with security as a fashion thing of a few people. That's where the rain began beating us. We all accepted that insecurity is a big concern in the country. Nobody is saying it shouldn't be dealt with. But to have thought that the laws were the missing plank was a wrong one, because when you begin to do a proper diagnosis, you notice that that's not the issue. But we've already now moved, and this has happened. It's taken us so much human time and resources as a country discussing the act. And what we need to come back to is, yes, these changes were proposed. Hassan talks about 11 that were dropped. Most of those that were dropped is because politicians began to see themselves becoming victims. So they quickly,
You're right, actually.
they quickly agreed, because of designating places of meetings and time, politicians from the divide saw themselves being victims.
You're right.
And those were immediately dropped. That begins to tell you how partisan a process of lawmaking is.
Yeah.
That we're not doing this from what John Rawls calls a veil of ignorance, that make the law not because you are the one who's going to enforce it or who's going to be affected with it, but because it will help any other person who may be in your position or not in that position. This law is being made with people who are in a position of privilege, and they want to use it to extinguish the other. So that's one challenge.
Yeah.
But two, I think getting to Justice Odunga's thinking, one, for me, the court has done one great thing. It has brought back an understanding that every agency, every organ of state has to be held accountable. There is none that will run on its own whims and say, because we were elected, because I'm in office, because I was appointed and I have a 5-year or 4-year term, allow me to do my work, don't ask questions.
Yes.
Justice Odunga has reinforced that all of us would be held accountable, and that's the minimum the Constitution requires.
Okay.
The second thing that I would want to say is, yes, he has accepted that there were certain provisions that were challenged. And he spoke on all the 13 that the two petitions wanted to speak to directly. And at no one point did he say any one of them was constitutional. He said it needs to be further reviewed. That's why he is referring it to a 3-judge bench. So let's not get into this mode of, again, Jubilee Code. This is where, again, it gets problematic.
All right.
I'm of the opinion, let Jubilee people sit back. They are a political party. Code should sit back. It's a political party.
Right.
Let's discuss this law for the sake of the nation. Where interests of political parties converge, we can come back to it. But if we go to court thinking that this is a Code Jubilee issue, again, we're not helping the country.
All right, finally, before we wrap up, we're done.
I think I can see that my friend here did not even read that act, that legislation. It was a legislation that amended the various legislations. In other words, it would have been called a miscellaneous amendment bill. You get it? And Senator, it is true that I posted on my Facebook page that certain provisions were draconian, some of them were outrightly unconstitutional.
Yes.
And I was asking why, because that was giving fodder to the other side of the country, actually to throw mud at the president. We all know that the president is not a lawyer, it is a team. So when this legislation is being done, it is the responsibility of these people to check which one contradicts the Constitution and which one does not. So that when court took up the issue and took it to court, it was clear any judge would have set aside some of them. And they will be set aside even if we went on appeal.